To Hybiz News, I am Suresh Kochatan. The US State Department has proposed not to issue temporary business visas for H-1B specialty occupations, which allowed several companies to send their technology professionals for a short stay to complete jobs on site in the United States, a move which could affect hundreds of Indians. The proposal, if finalized, will eliminate any misconception that the B1 in lieu of the H policy provides an alternative avenue for foreign professionals to enter the United States to perform skilled labor that allows and potentially even encourages them and their employers to circumvent the restrictions and requirements relating to the H non-immigrant classification established by Congress to protect the United States workers, the State Department said. The move, made public on Wednesday, less than 2 weeks ahead of the November 3rd presidential election, is likely to impact several Indian companies, which send their technology professionals on B1 visas for short stay to complete their jobs on site in the United States. On December 17, 2019, the Attorney General of California announced a US $800,000 settlement against Infosys Limited to resolve allegations that approximately 500 Infosys employees worked in the state on Infosys-sponsored B1 visas rather than H-1B visas, the State Department said. The proposed changes and the resulting transparency would reduce the impact of foreign labor on the US workforce of aliens performing activities in specialty occupation without procedural protection, attendant to the H-1B classification, it said. In its federal notification issued on Wednesday, the State Department said that the United States architecture firm seeking protection from rising labor costs in the country might believe that it could lay off its US architects and contract for the same professional architecture services to be provided by a foreign architecture firm. If the foreign firm sought H-1B visas for its architect, it would be required to pay the prevailing wage for architects in the area of intended employment in the United States, presumably the same wage US architects had been paid, and meet the other requirements enacted by the Congress to protect US workers. But under the B1 in lieu of the H policy, the foreign architects could ostensibly seek B1 visas to travel to the United States to fill a temporary need for architecture services as long as they retain a residence in the foreign country and continue to receive a salary, perhaps significantly lower than what is customary for US architects, dispersed abroad by the foreign firm or under the auspices of a foreign parent or subsidiary. The State Department said that under the department's guidance, visas could be issued for multiple architects planning temporary work in the United States in certain situations. However, a foreign employer may succeed in undermining the United States immigration law and policy by rotating architects between the United States and the foreign country to effectively fill the position of one US architect at a significantly lower cost, the notification said. If the architects who intend to perform skilled labor are distinguished merit and ability, seeking to perform temporary architectural services of an exceptional nature requiring such merit and ability, one might argue that the current regulatory language suggests this type of labor is a permissible basis for B1 non-immigrant issue visa. The State Department said that the potential outcome is harmful, may be harmful to the US workers, contrary to the policies of the Trump administration. The State Department also said that the application process for B1 visa does not include similar procedural requirements to protect the US workers like that of the H-1B visas. Also, the fees for the B1 visa are far less than that of H-1B visas. While Congress requires H-1B employees to pay significant fees to fund assistance to US workforce, as well as prevention and detection of fraud related to skilled laborers, employers are not required to pay the comparable fees to employ skilled workers under the B1 in lieu of the H policy, it said. According to the notification, State Department estimates that this proposal will affect not more than 6,000 to 8,000 foreign workers per year, specifically aliens intending to provide services in a specialty occupation in the United States. As per its estimate, 28% of the approximately 8,000 annual B1 visa issuance under the B1 in lieu of H policy were foreign workers who applied to visit for a visa to perform the services in a specialty occupation for a small entity in the United States.